everyone. Today our topic is to know everything about marriage registration laws in India. Let us come to introduction. What is meant by marriage? Marriage is considered a sacred institution in Indian culture. We all know that marriage is nothing but to live together by agreeing to stay the rest of their lives. For this marriage, we have to follow some legal statutes or status according to laws in India. After the marriage, which is solemnized between the bride and groom, we have to follow certain conditions which must be to follow with the legal status and therefore valid according to the current laws in India. Due to diversity of cultures in India, which we are following now in present scenario, the framers of the laws on this issue found that it is very difficult to provide a legal procedure for registering and solemnizing marriages. So, for this, we are keep in mind that if any law or any policy that proves harmful to a certain nation's customs, religion may encounter popular opposition. Now, we go with the challenges with the marriage registration laws. Currently, there are two sets of laws designed to address the challenge of marriage registration in different cultures. Coming to first one, which is very important, Hindu Marriage Act in 1955. And second one is Special Marriage Act, which is in 1954. 1954 Special Marriage Act is very crucial role in that year. Coming to Hindu Marriage Act 1955, which deals with registration of marriages, which in cases where the husband and wife are Hindus, Buddhist, Jain or Sikh or have converted to any of these religions. So we all know that the Hindus, Buddhists, Jains or Sikhs or any of the person who are willing to convert of any of the religion which are converted into Hindu Marriage Act 1955. And it is very important to note that the Hindu Marriage Act is only concerned with the registration of marriages that have been solemnized. So, whereas Special Marriage Act 1954, which provides for the solemnization and registration of marriages for the husband or wife or both are in Hindus or a husband is a Hindu or wife is a Buddhist, for example. So, husband is a Jain or wife belonging to Sikh. So, it is not problem and it comes under Special Marriage Act 1954. Court's duty is to ensure that the rights of both husband and wife are protected. Now, we see in cases where the cohabitation between husband and wife is broken, then it must be determined whether the break is due to the action of one party or not. So, coming to basic content of marriage registration, one of the party like husband or cohabitation between husband and wife which is broken and it must be determined it is a breaking or it comes under the break due to the actions of one party or not. So, let us check all those duties and the court have main duty to ensure all those rights of both husband and wife which are protected by law. Now, Hindu Marriage Act 1955. A marriage between a Hindu man who converted to Christianity and a Christian woman who converted to Hinduism is not a legal marriage. Section 5 of the Act, marriage can be dealt with solemnized between two Hindus. So, coming to Hindu Marriage Act, the Hindu Marriage Act only deals with both the husband and wife belongs to Hindu only or Hindu, Jain, Buddhist or any other religion. Here, a marriage between a Hindu man who converted to Christianity or a Christian woman who converted to Hinduism is not a legal marriage. Hinduism converted to Hinduism is nothing but a changing of a religion. So here, the Hindu Marriage Act 1955 deals with the rituals to be followed in a Hindu marriage. Under Section 7, Hindu marriages can be performed according to customary rites and rituals of either party. Here, rituals to be followed in a Hindu Marriage Act like to be performed according to customary rites. Customary laws, we already know that customary laws belonging to Hinduism, Buddhism, Jain, Sikhism, etc. And rituals of either party. Now let us go with the next step. A marriage can be solemnized between two Hindus in the following conditions which are required or valid. Here, neither party is incapable of giving valid consent due to their mental disorder. Next one, Although, if they were capable of giving valid consent, but none of them must be suffered with a mental disorder, so such as to render them unfit for a marriage. Here, none of them suffer from recurrent bouts or madness, which is very important in this marriage law. Both the persons are to be sound minded. The groom is at least 21 years old and bride is 18 years old at the time of marriage. We have to follow these rules and regulations which are provided by our law have to be followed strictly. When these rituals and ceremonies include saptapadi, that is known as the groom and bride taking 7 steps together before the sacred fire, the marriage becomes complete and binding when the 7th step is taken. Here the marriage is completely end by taking their promise to live together in their rest of their lives. Coming to next part, Special Marriage Act 1954. As we all know that the Special Marriage Act which deals with both the ceremony, celebration and registration of marriage. Under this act, certain conditions which have to be fulfilled or specified and which is essentially similar to what is provided in Section 5 of the Hindu Marriage Act 1954. Neither party is allowed to have a surviving spouse at the time of marriage, which is physical and mental capabilities of each party must match the requirements of the section. So, each party should have equal treatment of acceptance and equal priority of capabilities of each party have to be taken to be in requirements. Here, according to this law, there is no religious ceremony which is prerequisite for a successful marriage. And the law mainly stipulates the following conditions which are mentioned under Article 4, which is a legal and valid, which were considered by the court. At age of parties, male over 21 years old and female over 18 years old, as we all know at the present scenario. And here also same thing, the parties are not within the scope of the prohibited relationship, provided that the governing customs of either party which permits such marriage between them. Here the parties which are not within scope of prohibited relationship, like they have to broke in some days or some years which are casually following with the rules and regulations by Marriage Act, they have not entitled to enter the party. So the prohibited relationship must be occurs. So there is no acceptance of that scope in that Marriage Act 1954, which we all discussed in previous slides. Coming to next part, in Special Marriage Act, for initiating the process of marriage registration under this act, we have to submit the documents under the sub-registrar office. Before submitting of the documents, we have to do one of the main thing, that both the parties have to give a 30-day notice to sub-registrar in whose jurisdiction at least one spouse has been resided. Here, at least one spouse of jurisdiction has to be mentioned and have to submit a 30-day notice to sub-registrar under this act, under the Special Marriage Act. And next one is Hindu Marriage Act. For Hindu Marriage Act, it is a concluding process after due verification of all the documents submitted by the parties. When the documents which are submitted for verification, and after the verification completed, a day is fixed for registration by gazetteer officer, and have to fix one day, and the parties who are accepted to enter into the legal framework of the marriage have to present on the third day before the subdivisional magistrate. And here both the parties along with the gazetteer officer who attended their marriage are required to be present on the day before the subdivisional magistrate. So here, as we all know that the legal framework of the marriage have to follow some legal statutes according to the provisions of law in India. Up to now, we are aware with what is meant by marriage, what is Hindu Marriage Act and what is Special Marriage Act and essential of Marriage Act and the provisions related to Marriage Act which is important to enter the groom and bride for their rest of life in their agreeing legal statutes or legal framework. Now, I would like to conclude my topic. Hindu Marriage Acts in India can be registered under Hindu Marriage Act 1955 and Special Marriage Act in 1954. As we all know that in perspectives of special laws on marriage applies to all Indian citizens only and regardless of their religion. Now, Marriage can be solemnized but not allow the registrar to perform the marriage ceremony. The registrar who are giving with the registration process, they need to follow with the steps which are given by the procedure to give the registration, but not to do their marriage ceremony. As like that, we have to thanks in advance for the technology which is given us in present scenario. Now people can register their marriage in online. A part of that, they need not to attend the marriage registration office. They need to follow with the online process or online steps, by eliminating the need of regularity to attend the visiting of registration office. A part of that, as this article clearly states, which is necessary to obtain a marriage certificate after the ceremony. When the ceremony is completed, then the marriage have to be in a legal framework. They have entitled to live their life with freely and freely by their marriage certificate. So they have not obliged to follow other ways. Thank you.